Hi everyone, welcome back. This is Public International Law Part 3 of full series. So, the first topic we are going to discuss in this session is nationality. An individual who owes permanent alliance to a state is known as national of the state. Nationality refers to the political status of an individual who is attached to a state by the tie of allegiance. The term nationality signifies the legal tie between individual and the state. Nationality of a person is determined in accordance with the rules of municipal law. A state is entitled to protect the person and property of its nationals in foreign country. If a national of a state is expelled from a foreign state, it becomes the duty of the former state to receive back its national. The refusal to receive back and expulsion of a state's own national are inconsistent with the international law. Modes of acquisition of nationality. A person may acquire nationality of a state in accordance with the rules of municipal law. Rules of municipal law regarding acquisition of nationality are not same in all countries. The following are the usual modes by which nationality may be acquired. That is by birth, by descent, by naturalization, by registration. So by birth, a person may acquire nationality of a state in which he was born. By descent, a person may acquire nationality of a state on the basis of the nationality of either parents. Then by naturalization, a person who is a national of a state may acquire nationality of another state by following the procedure prescribed under the municipal law of the state. A person may acquire nationality through naturalization in different ways, such as through marriage, by acquisition of domicile, or by appointment as government official. Now, the last mode, that is by registration. A person may acquire nationality to a state through registration. A person may lose his nationality of a state by release, deprivation, renunciation, or substitution. So, one may acquire nationality by birth or by descent or by naturalization or by registration. There are 4 modes for acquiring nationality. Same way, there are 4 modes for losing a nationality. And for one may lose his nationality by release, deprivation, renunciation, or substitution. And double nationality. A person may have nationality of 2 states at the same time due to the lack of uniformity in municipal law. When a person has nationality of 2 states at the same time, it is known as double nationality. A child may get nationality of a state in which it is born as per the municipal law of the state. The parents of the child may be nationals of another state. By virtue of law of the state to which the parents are nationals, may also confer nationality of the state to the child. Then the child will get 2 nationality. It is a case of double nationality. Marriage of a woman with a man who is a national of another country may also result in double nationality. In a third country, such a person who has double nationality would be treated as having only one nationality. He will be treated as national of the country in which he habitually resides or the country with which he appears to be most closely connected. And then there is statelessness. Statelessness is a situation when a person has no nationality of any state. It may result due to the conflict of municipal laws. The situation of statelessness may arise by birth, marriage, or willful act. The interest of such person may not be protected by any state. So that is with nationality. The next topic we have is international treaties. According to Professor Oppenheim, treaties are agreements of a contractual character between states or organizations of states, creating legal rights and duties. According to Article 2 of the Vienna Convention on Law of Treaties, VCLT 1969, treaty is an agreement whereby 2 or more states establish or seeks to establish relationship between them governed by international law. Under international law, law-making treaties are considered to be the most important source of law. A treaty creates binding obligation on the states or international organizations who are parties to it. Basis of binding force of international treaty, that is mainly pacta sunt servanda. In view of Italian jurist Ancelotti, pacta sunt servanda is the basis of the binding force of international treaties. The principle means that states are bound to fulfill in good faith the obligation assumed by them under agreements. The International Court of Justice has described it as time-honored basic principle. In words of Edward Collins, the most fundamental principle of international law and surely the basic principle of treaty is that of pacta sunt servanda. Article 26 of Vienna Convention on Law of Treaties 1969 provides that every treaty in force is binding upon the parties upon it and must be performed by them in good faith. Thus, the convention recognized pacta sunt servanda as the basis of binding force of international treaties. Now, who can enter into a treaty? Under international law, only sovereign states and international organizations can be parties to an international treaty. Now, the formation of a treaty. In the formation of a treaty, the first step is accreditation of agents or persons, and then the second, negotiations and adoptions, third, signature, and the fourth, ratification. Fifth one is accession or adhesion. Then the sixth one is registration and publication. So, accrediting of agents or persons. The first step in the formation of a treaty is that the states authorizes some representatives to represent them for the negotiation, adoption, and signature of a treaty. The second stage or step is negotiations and adoptions. The accredited persons of the states enter into negotiations and settle the terms of the treaty. The third step is the signature. At a formal session, the accredited representatives of the parties to the treaty sign the document evidencing the treaty. The fourth step is the ratification. After negotiation, adoption, and signature of the treaty by the authorized representatives of the state, the next important step is the ratification of the treaty. The ratification is the approval by the head of the state or the government of the state which is a party to the treaty. Ordinarily, a treaty comes into force when it has been ratified by the states which are parties to it. Under international law, there is no duty upon a state to ratify a treaty signed by its representatives. Now, the fifth step is accession or adhesion. Those who have not signed the treaty may also accept the terms of treaty subsequently, and it is called accession. Accession occurs before ratification. When a state which is not a party to the treaty accepts the terms of treaty after ratification, that is called adhesion. Now, the final step is registration and publication. The next important step is the registration and publication of the treaty. By virtue of Article 102 of the UN Charter, every international treaty entered into by the members of the UN organization are to be registered with the UN. If the treaty is not registered with the UN, it cannot be invoked before any organ of the UN. The object of this provision is to prevent the practice of secret agreements between the states. Now, how can treaties be terminated? Termination of treaties. A concluded treaty may be terminated by operation of law or act of parties. A treaty may be terminated by operation of law in the following ways. 1. Extinction of either party to a bilateral treaty. 2. By outbreak of war. 3. Impossibility of performance. 4. Rebus sic stantibus. Then 5. Expiration of fixed term. Then 6. Jus cogens. Now, rebus sic stantibus. The maxim rebus sic stantibus means that when the fundamental or material circumstances under which a treaty is concluded are changed, then the change becomes a basis of avoidance or termination of treaty. Rebus sic stantibus is based on the assumption that there is an implied clause in every treaty that the agreement is binding only so long as the material circumstance on which it rests remains unchanged. Jus cogens. The word jus cogens means emergence of a new peremptory norm of international law. By virtue of Article 53 of Vienna Convention of Law of Treaties, a treaty is void if at the time of its conclusion it conflicts with the peremptory norm of general international law. A peremptory norm of general international law is a principle accepted and recognized by the international community of states as a whole from which no derogation is permitted. Then we have pacta tertis nec nocet nec prossent. It is the fundamental principle of law of contract that only parties to the contract are bound by the contract. Similarly, it is a general principle of international law that only a party to an international treaty is bound by it. The principle is expressed in the maxim pacta tertis nec nocent nec prossent. Article 34 of the Vienna Convention on Law of Treaties 1969 recognizes this principle. However, there are certain exceptions. They are 1. Multilateral treaties declaring the established customary principle of international law may bind even non-parties. And the second one, multilateral treaties which create a new rule of international law may also bind non-parties. Article 2 of the UN Charter provides that the members shall act in accordance with the purpose of UN Charter. It is an example which shows the binding nature of multilateral treaties to non-parties. So that is with treaties. The next topic we have is the United Nations Organization, UNO. After the First World War, the League of Nations was established in 1920. League of Nations in 1920 after the First World War. But it failed to prevent the Second World War. The Second World War once again compelled the nations of the world to endeavor to establish an international organization which could prevent further and future war and maintain peace and security in the world. During the Second World War, itself the great powers had started making efforts in this direction. Their efforts led to the holding of the San Francisco Conference of 1945. San Francisco Conference 1945, in which the UN Charter was adopted and signed by 51 nations of the world. The Charter came into force on October 24, 1945, after it was ratified by the prescribed number of states. The UN is considered to be an association or organization of states. It has a distinct legal personality of its own apart from those of its members. The ICJ, that is the International Court of Justice, in the case of reparation for the injuries suffered in the service of the UN, held that UN is a legal person and a subject of international law. It has rights and duties under international law. It can claim compensation for injuries suffered by the persons in its service. The UN has at present 193 member states. Some more member states are likely to join in the future. Now, objects of UN. The following are the objects of the United Nations Organization. There are mainly 4 of them. The first one, to maintain international peace and security. The second, to develop friendly relations among nations. Third, to achieve international cooperation in solving international problems of economic, social, cultural, and humanitarian character. And the fourth one, to prevent and encourage respect for human rights and fundamental freedom for all without distinction as to the race, sex, language, religion, etc. Now, the basic principles of UN. The first one, all member states are equal. It is not an absolute principle. The permanent members of the Security Council possess more power than other members. The second one, all members shall fulfill in good faith the obligation assumed by them in accordance with the UN Charter. The third, all members shall settle the international disputes by peaceful means. The fourth one, all members shall refrain from the threat or use of force against the political independence of any state. The fifth one, all members shall give the UN every assistance in common action it takes in accordance with the UN Charter and shall refrain from giving assistance to any state against which the UN is taking enforcement action. The sixth one, the UN is prohibited by intervening in the domestic affairs of a member state. Now, membership. The membership of the UN may be classified under 2 heads, that is the original members as well as the states or admitted as state members. Original members of the UN are those states which are participated in the UN conference at San Francisco. A state may be admitted to the UN on the affirmative recommendation of the Security Council and by resolution of the General Assembly by 2/3 majority. So, recommendation of Security Council plus resolution of the General Assembly by 2/3 majority. In order to admit a state in the UN, the following are the essentials. That is 5 essentials. That is, it must be a state, It must be a peace-loving state. It must accept the obligation of the UN Charter. It must be willing to carry out those obligations. It must be able to carry out those obligations. Now, the withdrawal of membership. There is no provision in the UN Charter for the withdrawal of membership. Then comes the expulsion of a member. If a member of the UN persistently violates the provisions contained in the UN Charter, it may be expelled from the organization by the General Assembly upon the recommendation of the Security Council. And then we have suspension of members. A member of the UN against which preventive and enforcement action has been taken by the Security Council may be suspended from the exercise of rights and privileges of membership. Suspension is to be done by the General Assembly upon the recommendation of the Security Council. Now, principal organs of the UN are General Assembly, Security Council, the Secretariat, the International Court of Justice, the Economic and Social Council, and the Trusteeship Council. Now, General Assembly. The General Assembly of the UN is the most democratic and representative organ. Each member state can send 5 representatives in the General Assembly. Each member is entitled to 1 vote. At present, there are 193 members in General Assembly. Now, the functions and powers of General Assembly. The first one is deliberative function. Then the second is supervisory function. The third is financial function. The fourth is elective function. And the fifth is constituent function. So, deliberative function. It refers to the function of General Assembly regarding discussion, studies and recommendations and passing of resolutions on different matters. Then comes supervisory functions. It refers to those functions which the General Assembly can supervise the functions of other principal organs and specialized agencies of the UN. The third one is financial functions. The General Assembly performs important financial functions. It considers and approves the budget of the UN. The fourth one is elective function. The General Assembly elects a new member to the UN and the members of other organs of the UN. The fifth one is the constituent function. The General Assembly performs important constituent function. It can amend the UN Charter. So these are the 5 functions and powers of General Assembly. And then we have Security Council. That is another body under UN. The Security Council is one of the principal organs of the UN. It consists of 15 members, out of which 5 are permanent and 10 are non-permanent members. America, Britain, China, France and Russia. America, Britain, China, France and Russia are the permanent members of Security Council. The 10 non-permanent members are elected by General Assembly for a term of 2 years. Each member state is entitled to send 1 representative in the Security Council. Now, with respect to voting rights, each member of the Security Council is entitled to cast 1 vote. The matters which come for the decision of the Security Council are classified into 2 heads. They are procedural matters and substantial matters. Decisions on the procedural matters are being taken by the majority of all members. When Security Council takes a decision on procedural matter, affirmative vote of 5 permanent members is not required. In procedural matters, permanent members have no veto power. Decisions on substantive matters require the affirmative vote of 9 members, including the 5 permanent members. If a permanent member gives a negative vote called veto, the Security Council becomes unable to take decisions on the matter. So that is with respect to Security Council. Now, and the voting rights. Now, double veto. The decision of the Security Council on all important and substantive matters shall be made by an affirmative vote of all members, including the affirmative votes of the permanent members. Whenever there arises whether a matter is procedural or substantial, the decision on that matter is substantial, and a permanent member can exercise this power of veto and convert that matter into substantive matter. Again, when the substantive matter comes for the decision of Security Council, the permanent member which earlier exercised veto power can exercise veto power. It is called double veto. Now, the functions and powers of Security Council. So, the Security Council has mainly 4 functions and powers, that is maintenance of international peace and security. The second one is electric foundation. Third one is supervisory function. And the fourth one is constituent function. So, maintenance of international peace and security. The primary responsibility of the maintenance of international peace and security is upon the Security Council. Then we have the elective function. The Security Council performs some elective function. The Security Council participate in the election of judges of the ICJ. A state can be admitted to the UN only on the recommendation of the Security Council. The Security Council also recommends the appointment of the Secretary General of the UN. Then the third is supervisory function. The Security Council performs some supervisory function. It can recommend the expulsion and suspension of members. Then we have the constituent function. Amendment to the UN Charter is possible only if all the permanent members of the Security Council give their affirmative vote on it and it is subsequently ratified by their respective governments. The Secretariat. Now, going towards the Secretariat is one of the principal organs of the UN. The Secretariat comprises of the Secretary General and its staff. The Secretary General is appointed by the General Assembly upon the recommendation of the Security Council. He is the chief administrative officer of the organization. The appointment of the Secretary General is substantial matter and the affirmative vote of 5 permanent members is necessary. And then we have International Court of Justice or ICJ. The International Court of Justice is one of the principal organs of the UN. It is constituted according to the Statute of International Court of Justice, which is a legal part of the UN Charter. The International Court of Justice consists of 15 judges. They are elected by the General Assembly and the Security Council separately. These judges are elected for a period of 9 years and also be reappointed after the expiry of their term. All the decisions of the court are made on the basis of majority of the judges. The president of the court is empowered to give casting vote in case of a tie. The seat of the court is at Hague, Netherlands. Now, towards jurisdiction, the ICJ is open for all states of the world. Only the states may be parties to any dispute before the court. International organizations may request the court to give advisory opinion on legal matters. The ICJ has jurisdiction to decide all cases which are parties refer to it, and the decision of the court shall be binding upon the parties. This jurisdiction of the court is known as voluntary jurisdiction. By virtue of Article 36, Clause 2 of Statute of International Court of Justice, the state parties of the statute can confer compulsory jurisdiction upon the court by making such declaration in respect of any other state, which also accepts similar obligations. This can be done without any special agreement to the same effect. This is called optional jurisdiction of the court. The Security Council is empowered to implement the decisions of the ICJ in case one of the parties fails to implement it and the other party to the dispute brings the matter to Security Council. The next organ of the UN is Economic and Social Council. The Economic and Social Council is another principal organ of the UN. This organ consists of 27 members elected by the General Assembly. The members are selected for a term of 3 years. It may make studies and report with the respect to international economic, social, cultural, educational, health and related matters. It may make recommendations for the purpose of promoting respect for human rights and fundamental freedom for all. The final organ of the UN is the Trusteeship Council. The Trusteeship Council is one of the principal organs of the UN. The main function of the Trusteeship Council is to administer trust territories. So that is with United Nations organization and its organs. The next topic we have is international economic law. International economic law is a part of public international law. It is that part of public international law relating to the economic relations, investment, economic development, economic institutions, environment, and regional economic integration. International economic law regulates the international economic order or economic relation among the states. It is a convenient expression to cover mainly the multitude of bilateral and multilateral treaties made since the Second World War on international trade, commerce, investment, development, and environment. It is a field of public international law directly concerned with economic exchange between the subjects of international law. It includes 1. The background rules of private international commerce, and 2nd, the architecture of global trading and monetary systems, and the 3rd, the principles of international development and investment. So the first one, the background rules of private international commerce. The second, the architectures of global trading and monetary systems. And the third, the principles of international development and investment. This is with respect to international economic law. Now, international economic law encompasses both the conduct of sovereign states in international economic relations and the conduct of private parties involved in cross-border economic and business transactions. International economic law is not derived from a single source or even several sources of law. It has its genesis in many. The international, regional, national, and non-governmental entities produce a wide range of documents, including international conventions, treaties, bilateral agreements, model laws, guidelines, statistics, and interpretative materials. Now, national, regional, and international law, that is public as well as private international law, policy, and customary practices are all components of international economic law. International economic law encompasses a wide spectrum of subjects, including trade in goods and service, financial law, economic integration, development law, business regulation, and intellectual property. The basis of international economic law is that international economic law is based on the traditional principles of international law, such as the first one, pacta sunt servanda, that is, a pact made shall be respected or an agreement made shall be served. Now the freedom, then second one is freedom, third one is sovereign equality, then fourth is reciprocity, and the fifth one is economic sovereignty. So international economic law is based on the traditional principles such as one, pacta sunt servanda, then it is freedom, then sovereign equality, then the fourth one reciprocity, and the fifth one economic sovereignty. It is also based on modern and evolving principles such as the duty to cooperate, permanent sovereignty over natural resources, preferential treatment for developing countries in general and the least developed countries in particular. So that is with international economic law. The next topic we have is the International Bank for Reconstruction and Development, that is IBRD, International Bank for Reconstruction and Development, IBRD, and it is popularly known as World Bank. The Bretton Woods Conference, formerly known as the United Nations Monetary and Financial Conference, United Nations Monetary and Financial Conference, was a gathering of 730 delegates from all 44 allied nations at the Mount Washington Hotel situated in Bretton Woods, New Hampshire, United States, to regulate the international monetary and financial order after the conclusion of World War II. The conference was held in July 1944. Agreements were executed that later established the International Bank for Reconstruction and Development, IBRD, International Bank for Reconstruction and Development, and International Monetary Fund, IMF. The IBRD was created to speed up post-war reconstruction, to aid political stability, and to foster peace. This was to be fulfilled through the establishment of programs for reconstruction and development. The bank issued its inaugural loan of $250 million to France in 1947. The inaugural loan of $250 million to France in 1947 to finance infrastructure projects. Throughout the remainder of the 1940s and 1950s, the bank financed projects seeking to dam rivers, generate electricity, and improve access to water and sanitation. It also invested in France, Belgium, and Luxembourg's steel industry. Following the reconstruction of Europe, the bank's mandate has transitioned to eradicating poverty around the world. In 1960, the International Development Association, IDA, was established, that is in 1960, was established to serve as the bank's concessional lending arm and provide low and no-cost finance and grants to the poorest of the developing countries as measured by gross national income per capita. So it is measured by gross national income per capita. Today, IBRD or the World Bank provides loans and other assistance primarily to middle income countries. IBRD is the original World Bank institution. Now it works closely with the rest of the World Bank Group to help developing countries reduce poverty, promote economic growth and build prosperity. So, reduce poverty, promote economic growth and build prosperity. The World Bank Group is a group of 5 international organizations. The World Bank Group gives advice and finance to member countries for economic development and reducing poverty. It is a non-profit making international organization owned by member governments. The group has its headquarters in Washington, D.C. The World Bank Group is made of the following 5 organizations. The first one, the International Bank for Reconstruction and Development, established in 1945. That is the initial popularly known as the World Bank. IBRD, International Bank for Reconstruction and Development, established in 1945. Then the second one is International Finance Corporation, IFC, International Finance Corporation, that is established in 1956. The third one, International Development Association, IDA, that is established in 1960. International Development Association, IDA, that is established in 1960. Then Multilateral Investment Guarantee Agency, MIGA, Multilateral Investment Guarantee Agency, that is established in 1988. Then the fifth one, the International Center for Settlement of Investment Disputes, ICSID, International Center for Settlement of Investment Disputes, ICSID, that is established in 1966. The World Bank is an international bank that lends money and provides other helps to developing nations for infrastructural developments. The World Bank has the goal of reducing poverty. The World Bank is different from the World Bank Group because the World Bank is made up of only 2 institutions, that is the IBRD and IDA, International Bank for Reconstruction and Development and International Development Association. So the World Bank is made up of 2 institutions, IBRD and IDA. The World Bank Group has these 2 but also 3 more, that is IFC, that is International Finance Corporation, then MIGA, Multilateral Investment Guarantee Agency, and ICSID, International Center for Settlement of Investment Dispute. The IBRD is owned and governed by its 188 member states but has its own executive leadership and staff which conduct its normal business operations. The bank's member governments are shareholders which contribute paid-in capital and have the right to vote on its matters. In addition to contributions from its member nations, the IBRD acquires most of its capital by borrowing on the international capital markets through bond issues. In fact, in these markets, IBRD is known simply as World Bank. The practice has allowed IBRD to provide more than $500 billion in loans to alleviate poverty around the world since 1946, with its shareholder governments paying in about $15 billion in capital. The institution provides a combination of financial resources, knowledge and technical services, and strategic advice to developing countries, including middle income and creditworthy lower income countries. IBRD is providing innovative financial solutions, including financial products, that is loans, guarantees and risk management products, and knowledge and advisory service to government at both the national and subnational level. IBRD finances projects across all sectors and provide technical support and expertise at various stages of a project. IBRD's financial product and services help countries build resilience to shocks by facilitating access to products that mitigate the negative impact of currency, interest rate and commodity price volatility, natural disaster and extreme weather. Though IBRD is primarily an international financial institution providing loans to developing countries. However, it has several branches and functions that make it touch the field of trade as well. The W Group, that is the World Bank Group, has specific trade programs which include 1. Promotion of multilateral trading system that is supportive of economic development. The second, making the trade competitiveness the centerpiece of the development strategies of the countries. And the third, supporting trade and facilitation of related reforms by way of the bank's aid or trade programs. In order to complement these programs, the bank launched its new trade strategy in 2011 after having consultations with the stakeholders. This new strategy is about leveraging trade for development and inclusive growth. According to World Bank, the strategy has 4 main priority themes. That is 1. Trade competitiveness and diversification. The second, trade facilitation as well as transport, logistics and trade finance. The third, supporting market access and the international trade cooperation. And the fourth, managing the shocks while promoting greater inclusion. So that is with International Bank for Reconstruction and Development, IBRD, which is popularly known as World Bank. The World Bank is comprised of 2 institutions, IBRD as well as IDA. The next topic we have is International Monetary Fund, IMF. The International Monetary Fund is an international organization. The IMF has 188 member countries. It was created in 1945. It has its headquarters in Washington, D.C., USA. In the 1930s, many countries faced economic problems. Some of such problems were falling the standard of living and unemployment by large number of people. Trading between different countries also came down. Some countries reduced the value of their currencies. All such factors combined and an economic depression resulted. By late 1939, the Second World War had started. After the Second World War was over, most countries found that the international value was not smooth and faced many restrictions. Leaders of many countries thought over these matters and discussed them in meetings. Thus, after the Second World War, many countries felt the need to have an organization to get help in monetary matters between countries. To begin with, 29 countries discussed the matter and signed an agreement. The agreement was the Articles of Association of the International Monetary Fund. So the agreement was Articles of Association of the International Monetary Fund. The International Monetary Fund came into being in 29th December 1945. 29th December 1945. Any country may apply to become a member of the IMF. When a country applies for membership, the IMF's executive board examines the application. If found suitable, the executive board gives its report to IMF Board of Governors. So the executives examine the application. If eligible, it is forwarded to the executive board of IMF Board of Governors. After the Board of Governors clear the application, the country may join the IMF. However, before joining, the country should fulfill legal requirements. If any, of its own country, every member has different voting right. Likewise, every country has a different right to draw funds. This depends on many factors, including the member country's first subscription to the IMF. So the voting rights as well as the right to draw funds depends upon the many factors, one of which is the country's first subscription to IMF. The IMF does a number of supervisory works relating to financial dealings between the different countries. Some of the works done by IMF are helping in international trade, that is business between countries, then looking after exchange rates. Another one is looking after balance of payments, then helping member countries in economic development, and it also provides a machinery of international consultation. The member countries contribute funds to a pool through a quota system from which countries with payment imbalances can borrow. Through this fund and other activities such as statistics keeping and analysis, surveillance of its members' economies and the demand for self-correcting policies, The IMF works to improve the economies of its member countries. The organization's objectives stated in the Articles of Agreement are to promote international economic cooperation, international trade, employment, and exchange rate stability, including by making financial resources available to member countries to meet balance of payment needs. So, the objective of the organization, as in the Articles of Agreement, that is to promote international economic cooperation, international trade, employment, and exchange rate stability, including by making financial resources available to member countries to meet balance of payments needs. So that is the objective as stated in the Articles of Agreement. The IMF's primary purpose is to ensure the stability of the international monetary system, the system of exchange rates, and the international payments that enables countries and their citizens to transact with each other. The fund's mandate was updated in 2012 to include all macroeconomic and financial sector issues that bear on global stability. Some of the main roles of IMF on international trade are: 1. Promotion of international monetary cooperation. 2. Facilitation of the expansion and balanced growth of international trade. 3rd, promotion of exchange stability. 4th, assisting to the establishment of a multilateral payment system. 5th, giving confidence to the members by way of making general resources of the IMF temporarily available to the members under adequate safeguards. And the 6th one, shortening of duration and lessening the level of disequilibrium in the aspect of international balances of payments among its member countries. So that is with IMF, International Monetary Fund, and established in 1945. The next topic we have is General Agreement on Tariff and Trade, that is GATT, GATT, General Agreement on Tariffs and Trade, World Trade Organization, WTO, and TRIPS, that is a TRIPS agreement. So this topic is of prominent, very highly prominent, not really with respect to public international law, but also with respect to transfer property as well as IPR and other fields. Now GATT, G-A-T-T, General Agreement on Tariffs and Trade. It is a multilateral agreement regulating international trade. According to its preamble, its purpose is to substantial reduction of tariffs and other trade barriers and the elimination of preferences on a reciprocal and mutually advantageous basis. So once again, according to its preamble, its purpose is substantial reduction of tariffs and other trade barriers and the elimination of preferences on a reciprocal and mutually advantageous basis. So that is with the purpose as mentioned in the preamble of GATT. General Agreement on Tariffs and Trade, that is GATT. It was negotiated during United Nations Conference on Trade and Employment and was the outcome of the failure of negotiating governments to create International Trade Organization. GATT was signed by 23 nations in Geneva on October 30, 1947 and took effect on January 1, 1948. It lasted until a signature by 123 nations in Marrakesh on April 14, 1994 of the Uruguay Round Agreements, which established the World Trade Organization WTO on Jan 1, 1995. So GATT was the predecessor of World Trade Organization. World Trade Organization came into being on January 1, 1995. The original GATT is still in effect under the WTO framework, subject to the modifications of GATT 1994. Now, World Trade Organization or WTO. The World Trade Organization is an intergovernmental organization. So, it is an intergovernmental organization which regulates international trade. The WTO has 161 members and 23 observer governments. 161 members and 23 observer governments. In addition to states, the European Union is a member. WTO members do not have to be full sovereign nation members. Instead, they must be a custom territory with full autonomy in the conduct of their external commercial relations. So, it need not be full sovereign nation members. Instead, they must be a custom territory with full autonomy in the conduct of their external commercial relations. The WTO officially commenced on 1st of January 1995 under the Marrakesh Agreement signed by 123 nations on 15 April 1994. The Marrakesh Agreement was signed on 15 April 1994 and WTO was established on 1st of January 1995. It replaced the General Agreement on Tariffs and Trade (GATT), which commenced in 1948. The headquarters of the World Trade Organization is in Geneva, Switzerland. The WTO's predecessor, GATT, was established after World War II. The GATT was the only multilateral instrument governing international trade from 1946 until WTO was established on 1st of Jan 1995. The GATT still exists as the WTO's umbrella treaty for a trade in goods, updated as a result of the Uruguay round of negotiations in 1994. So, the GATT is still existing as the WTO's umbrella treaty for trade in goods, updated as a result of the Uruguay round negotiations in 1994. GATT 1994 is not, however, the only legally binding agreement included via the final act of Marrakesh. A long list of about 60 agreements, annexes, decisions and undertakings was adopted. Now, with respect to the structure of WTO, the Ministerial Conference, that is the MC, is at the top of the structural organization of the WTO. So, at the top we have Ministerial Conference, MC. It is the supreme governing body which takes ultimate decisions on all matters. It is constituted by representatives, usually of ministers of trade of all the member countries. Now, then we have the General Council, that is GC. So, at the top we have Ministerial Conference and then we have General Council. Now, GC is composed of representatives of all the members. It is the real engine of WTO which acts on behalf of the MC. So, it acts on the behalf of MC. It also acts as the dispute settlement body as well as the trade policy review body. So, it acts as the dispute settlement body as well as the trade policy review body. Now, there are 3 councils. The councils with their subsidiary bodies carry out the specific responsibilities. Now, there are further 3 committees. So, we discussed about Ministerial Conference, General Council, the other councils, that is a Council for Trade in Service and the Council for Trade Related Aspects of Intellectual Property, that is the TRIPS. And then further there are 3 committees. The first one, Committee on Trade Development, CTD, Committee on Trade Development. Then we have Committee on Balance of Payments Restriction, Committee on Balance of Payment Restriction, CBOPR. Then we have Committee on Budget, Finance and Administration. So that is CBFA, Committee on Budget, Finance and Administration. Now, these committees execute the function assigned to them by the WTO agreement and the GC, that is General Council. So, General Council is composed of representatives of all its members and they act on behalf of the Ministerial Conference. Ministerial Conference generally is comprised of the Ministers of Trade of all the member countries. Now, the features of WTO, World Trade Organization. The distinctive features are: 1. It is a legal entity. 2nd, it is not an agent of the United Nations. 3rd, a WTO member have equal rights. 4th, The agreements under the WTO are permanent and binding to the member countries. The fifth one, the WTO dispute settlement system is based not on dilatory but automatic mechanism. It is also quicker and binding on the members. As such, the WTO is a powerful body. The sixth one, the WTO approach is rule-based and time-bound. Seventh, the WTO have a wider coverage. It covers trade in goods as well as services. Now, eighth one, the WTO have a focus on trade-related aspects of intellectual property rights and several other issues of agreements. Ninth one, the WTO is a huge organizational body with a large secretariat. Now, the main function, so that is with the distinctive features of WTO. Now, the main functions of WTO, the first one is trade negotiations. The second is implementation and monitoring. The third is dispute settlement. The fourth is building trade capacity. So we are going to discuss the four functions of WTO, that is trade negotiations, implementation and monitoring, dispute settlement, building trade capacity. Now, trade negotiations. This function covers agreements on goods as well as services and even intellectual property. Specifically, WTO, through this mandate, deals with ensuring commitment of every member state to lower their custom tariff and even other barriers of trade. Of course, these are in sync with the agreements of the members, which are being reviewed regularly. Now, implementation and monitoring. According to WTO agreements, its members are required to make their trade policies transparent. This is being done by notifying the WTO on the laws or measures that the members adopt. All of the members of the WTO are required to undergo regular scrutiny of their policies and practices related to trade. The third one is dispute settlement. Even though the WTO has some established procedures and guidelines, there still might arise a situation, a time when trade quarrels may arise. It is in this light that the members are covered by the dispute settlement understanding, which provides for rules in settling dispute. This usually happens most especially when a member thinks that their rights under their specific agreements are being violated. The judgments will be made by the appointed independent experts. Then the fourth one is building trade capacity. The WTO agreements also have some special provisions concerning developing countries in order to increase opportunities for their trading and supporting them to boost their trading capacity. Aside from that, the organization is also assisting these countries in handling dispute as well as implementing technical standards. These are being through annual courses offering that to aim to develop the country's skill and infrastructure requirements. The rules embodied in both GATT and the WTO serve at least three purposes. That is the first one. They attempt to protect the interests of the small and weak countries against the discriminatory trade practices of the large and powerful countries. The WTO's most favored nation and national treatment articles stipulate that each WTO member must grant equal market access to all other members and that both domestic and foreign supplies must be treated equally. Now, the second one is that the rules require members to limit trade only through tariffs and to provide market access not less favorable than the specified in their schedules. That is the commitment that they agreed to when they were granted WTO membership or subsequently. And the third one, the rules are designed to help government resist lobbying effort by domestic interest groups seeking special favors. Although some of the exceptions to the rules have been made, their presence and replication in the core WTO agreements were intended to ensure that the worst access would be avoided, by thus bringing greater certainty and predictability to international markets. It was thought that WTO would enhance economic welfare and reduce political tension. So that is with WTO, and then we have TRIPS. that is the trade related aspects of intellectual property rights. Now, rights with respect to intellectual property rights. Now, this WTO is also commonly known as the TRIPS agreement. That the TRIPS of WTO is commonly referred to as or known as TRIPS agreement or simply TRIPS. The TRIPS is one of the main agreements comprising the World Trade Organization agreement. This agreement was negotiated as a part of the 8th round of multilateral trade negotiations in the period 1986 to 1994 under General Agreement on Tariffs and Trade, that is GATT, commonly referred to as Uruguay Round, extending from 1986 to 1994. It appears as Annex 1C of the Marrakesh Agreement, which is the name of the main WTO agreement. The Uruguay Round introduced intellectual property rights into the multilateral trading system for the first time through a set of comprehensive disciplines. So it was the Uruguay Round that introduced intellectual property rights into the multilateral trading system for the first time through a set of comprehensive disciplines. The TRIPS agreement is a part of the single undertaking resulting from the Uruguay Round negotiations. This implies that the TRIPS agreement applies to all WTO members mandatorily. It also means that the provisions of the agreement are subjected to WTO dispute settlement mechanism, which is contained in the dispute settlement understanding, that is the understanding on the rules and procedures governing the settlement of dispute. The TRIPS agreement is one of the most important agreements of WTO. Now, why was TRIPS included in WTO? The precursor to the WTO was the GATT, which sought to address issues related to international trade in goods. The operation of GATT over the years resulted in lowering of tariff in general and in international trade. As a result, increasingly other domestic policies of nation came into focus of the trading nation. The developed countries, including United States, started facing increasing competition in the manufactured exports from newly industrializing countries of Asia. For intellectual property issues in general, the negotiators were required to clarify GATT provisions and elaborate as appropriate new rules and disciplines in order to reduce distortions and impediments to the international trade. As technology became more important in goods and commodities, having higher proportion of invention and design, that is intellectual creativity, in their value, IPR became more important in international trade. As a result, the Uruguay Round negotiations, the intellectual property right dominated the discussions. Now, what are the intellectual property rights and how do they grant protection to the owner of an IPR? Intellectual property rights or IPR are rights given to people for the creation of their minds. These rights are given by society through the state as an incentive to produce and disseminate ideas and express that would benefit the society as a whole. Unlike fundamental rights of citizen, which is guaranteed by constitution of a country, IPR are statutory rights enacted by lawmaking authority in a country. Conventionally, many forms of IPRs are recognized. They are traditionally classified into two main categories, that is copyright and related rights. Then industrial property. So those are the two main categories. So copyright and related rights, these are rights granted to authors of literary and artistic works and the rights of performance producers of phonograms and broadcasting organizations. The main purpose of protection of copyright and related rights is to encourage and reward creative work. The distinguishing feature of this category of right is that they protect only the tangible expression of an idea and not the idea itself. Further, these rights generally come into existence the moment a work is created and need not be registered with any central authority. The other category is industrial property. This category includes 1. The protection of distinctive signs such as trademarks and geographical indications, and the second, industrial property protected primarily to stimulate innovation, design and the creation of technology, which are protected through laws on protection of invention such as patent, industrial design and trade secrets. intellectual property rights are rights granted or protection to the owner, as they give the creator an exclusive right over the use of his or her intellectual creation, generally for a limited period of time. However, in the case of certain categories of IPR, the rights, that is, the trade secrets or geographical indications, can exist indefinitely so long as the right holder takes steps to protect his right. In this case of certain other time limited IPR, it is possible to renew the rights periodically, either for an indefinitely long period, as in the case of trademark, or for a pre-specified maximum limit, as in the case of industrial design. Which IPR are covered under TRIPS? The IPR covered by the TRIPS agreement are copyright and related rights, that is, the rights of the performers, producers of sound recording and broadcasting organizations, etc. Then trademarks, including marks. Then geographical indications, including appellation of origin. Then industrial design. Then patents, including the production of new varieties of plants. Then layout designs, topographies of integrated circuits. Then undisclosed information, including trade secrets and test data. So all these come under TRIPS. All these IPR comes under TRIPS. Now, what is the link between TRIPS, WTO and WIPO? Now, intellectual property right or IPR of a multilateral level have their genesis in the Paris Convention for the Protection of Industrial Property in 1883, which protected industrial property, that is patents and trademarks, and the Berne, that is Paris Convention and Berne Convention. So, Paris Convention for the Protection of Industrial Property 1883 and Berne Convention for the Protection of Literary and Artistic Works, that is in 1886, for copyrights and related rights. Now, World Intellectual Property Organization, that is WIPO, World Intellectual Property Organization, which began its work in 1967, taking over the Bureau of the Protection of Intellectual Property that had been working since 1893, is the international agency under the United Nations that administers the work of these conventions. The WIPO administers many other international conventions on IPR also. While the IPR conventions and treaties create the international standard in protection of IPR, which are to be followed by the member countries, substantive trade-related discipline on IPR under these international conventions have been adopted by reference into the WTO through the TRIPS agreement. This means that the agreement provides rules for trade and investment in ideas and creativity by incorporating standards laid down in certain exact provisions of the major IPR conventions. The WTO provides that intellectual property should be protected when trade is involved. Thus, through the TRIPS and WTO, the WTO makes it mandatory for all its member countries to follow basic minimum standard of IPR provided for under TRIPS and bring about a degree of harmonization of domestic laws in this field. Now, what is the importance of Doha Declaration on Public Health? So, earlier we discussed about Paris Convention as well as Berne Convention. Now, what is the importance of Doha Declaration on Public Health? Why was this necessary? The framework of stringent intellectual property rights established by the TRIPS agreement enables pharmaceutical manufacturers to change prices above marginal cost of production. This affects the ability of the governments to monitor and protect the public health because of their obligation to protect IPRs of the manufacturers. This means that the government may find their capacity to ensure affordable access to medication restricted. In 2001, in response to concerns of developing countries regarding limited or no access to medicines at affordable prices, the WTO members agreed to the issue the Doha Declaration to clarify the TRIPS agreement in context of public health. The declaration states that the TRIPS agreement would not prevent members from taking steps to protect public health and make clear that each member has the right to create certain exceptions to its IPR laws to enable it to grant compulsory license for manufacture of essential goods such as life-saving drugs even if the consent of the holder of the IPR is not forthcoming. Each member would be required to determine the grounds on which such compulsory license can be granted and shall have the right to determine what constitutes a national emergency. Based on a decision taken by WTO in 2003, member states may also grant a compulsory license for limited export and import of medicines where the receiving country lacks manufacturing capacity. So that is the importance of Doha Declaration on Public Health, and that was in 2001. Now, what are the challenges of Doha Declaration 2001? So, even though the Doha Declaration on TRIPS Agreement and Public Health and the implementation of paragraph 6 of the Doha Declaration on TRIPS Agreement and Public Health recognize the gravity of public health problems and reflect concerns regarding the implication of the TRIPS Agreement, these documents left a number of technical and legal problems unresolved. For example, since the term epidemics in the Doha Declaration has been left undefined, and even though the Doha Declaration acknowledged each member's rights to determine what constitutes a national emergency or a circumstance of extreme emergency, the governments may still face challenges from pharmaceutical manufacturers on whether they can issue compulsory license over certain medication. This means that the medication for chronic diseases such as HIV, AIDS, tuberculosis, malaria, and other epidemics may be interpreted as a restriction on this right, since the existence of a chronic disease may not qualify as a national emergency. There are also concerns that the administrative burden associated with the procedural arrangements required by the declaration for notifying the WTO of the mechanism to provide drugs and medicines to countries not having local manufacturing capacity under the 2003 decision will be costly and cumbersome, particularly for developing countries. Now, what are TRIPS plus provisions? TRIPS plus provisions. So, IPRs are territorial rights and can be acquired in the territory of the country having an IPR law. That is, IPR acquired in one country cannot be enforced in another country. The TRIPS agreement lays down only certain minimum standard of protection and enforcement of IPR by its members through enactment of such national laws and regulations. The TRIPS agreement, however, allows members to have higher level of protection than the minimum standard laid down in it, thus leaving the flexibility to members to have TRIPS plus laws and regulations. The developed countries are moving towards higher enhanced standards of IPR protection to involve TRIPS plus regime. These higher standards of IPR protection to evolve TRIPS plus regime are now making an appearance in various free trade agreements that these countries are negotiating and entering into with their trading partners. Since these provisions go beyond minimum standard established under TRIPS, they may take away the flexibilities. For example, the ability to issue compulsory license for medicines required in public health emergencies, etc. that exist in TRIPS agreement. These negotiate rules and commitments is bilateral, sub-regional and regional agreements that go beyond multilateral level in WTO. So, why TRIPS plus provisions are important in free trade agreements, and what are the consequences of this inclusion? By entering into free trade agreements with developing countries see some advantage in tariff reduction on agricultural, clothing, and other products. In return, developed countries seek better market access and investment opportunities for products and services of their interest. In addition, developed countries also seek to raise a minimum level of protection for IPR as they have a comparative advantage in technology, products, and services. At the same time, developing countries find it difficult to put forward the issue of their concern through the FTA negotiations, including the harmonization of TRIPS and CBD, access to the medicines, and the protection against the biopiracy of their biological genetic resources, farmers' rights and associated traditional knowledge, ability of their farmers to continue their subsistence and the livelihood related farming practices, and getting the same level of protection of their geographical indication as for the wines and spirits of the developed countries. As a consequence, free trade agreements create an imbalanced set of rights and obligations in favor of developed countries by ratcheting up the levels of IPR protection. While it can be argued that there is no bar on developing countries in walking away from unequal agreements, it can also be argued that owing to unequal negotiating strength, many bilateral agreements do turn out to be unequal. If the immediate need to be benefit from the reduced tariff etc. is high, then a developing country can be guided into making concessions in areas of longer term impact such as IPR. Now, what are the future issues under consideration relating to TRIPS? Some of the issues that are under debate relating to TRIPS are the effectiveness of the 2003 waiver in 2001 Doha Declaration on TRIPS and Public Health. The waiver in Doha Declaration removes a requirement that generic produce under compulsory license should be mainly for the domestic market. This would hinder their export to countries that cannot make the medicine. The TRIPS agreement has been amended in 2005 to include these provisions in it, but the amendment has not come into force as most members have not ratified it so far. In addition, the mechanism established in 2003 waiver for providing affordable medicines to poor countries does not seem to have worked, as only one case of it if its use exists. That is where Rwanda obtained medicines from Canada, and that too has not been very successful. WTO members are reviewing this provision. The TRIPS agreement has built in review the provision relating to the patenting of life forms. The current provision obliges members not to exclude from their patent regime microorganisms and non-biological and microbiological processes. It also obliges members to protect plant varieties either through patents or through a sui generis system or a combination thereof. This review has not been concluded, even though it started in 1999. Protection of the innovations of indigenous and local farming communities and the continuation of the traditional farming practices include the right to save, exchange seeds and sell their harvest. Now, the protection of the rights of indigenous communities and prevent any private monopolistic intellectual property claims over their traditional knowledge. And the last, grant of the same level of protection of geographical indication in other products as is granted to wines and spirits. So that is with this session. The next topic we have is New International Economic Order. The New International Economic Order, NIEO, was a set of proposals put forward during the 1970s by some developing countries through the United Nations Conference on Trade and Development, that is UNICTAD, United Nations Conference on Trade and Commerce, to promote their interest by improving their terms of trade, increasing development assistance, developed country tariff reduction and other means. At the 6th special session of the United Nations General Assembly in 1975, a declaration was made for the establishment of New International Economic Order, NIEO. It is regarded as a turning point in the evolution of the international community. NIEO is to be based on equity, sovereign equality, common interest and cooperation among all states, irrespective of their social and economic systems, which shall correct inequalities and redress existing injustices, make it possible to eliminate the widening gap between the developed and developing countries, and ensure steadily accelerating economic and social development and peace and justice for the present and future generations. So that is the motto of NIEO. The NIEO aims at the development of the global economy as a whole, with the setup of interrelated policies and performance targets of the international community at large. With respect to the objectives of the NIEO, that is the New International Economic Order, in essence, the New International Economic Order aims at social justice among the trading countries of the world. It seeks restructuring of existing institutions and forming new organizations to regulate the flow of trade, technology, capital funds in a common interest of the world's global economy and due benefits in favor of the least developing countries, that is LDCs. It has the spirit of a world without borders. It suggests more equitable allocation of the world's resource through increased flow of aid from the rich nations to the poor countries. It seeks to overcome world mass misery and alarming disparities between the living conditions of the rich and the poor in the world as large. Its aim is to provide poor nations increased participation and have their say in the decision-making process in the international affairs. Among two other objectives, the new international economic order envisages the establishment of a new international currency, the implementation of SDR aid linkage, the increased stabilization of international floating exchange system, and the use of IMF fund as its interest subsidy on loans to poorest developing countries. The crucial aim of NIEO is to promote economic development among the poor countries through self-help and South-South cooperation. Now, the NIEO intends to deal with the major problems of the South, such as balance of the payments disequilibrium, debt crisis, exchange scarcity, etc. The program of action for the NIEO, that is, the UNICTAD resolutions, provide a source of program of action for the international economic order. The new international economic order is not in favor of existing system of free market orientation. It is based in the less developed countries through interventionist approach. Its action program narrates the need for a more rapid economic development of the poor countries and their increasing share in the world's trade at favorable terms of trade. Its line of action is to adopt discriminatory approach in trade favoring the LDCs, that is the least developing countries, that is LDCs. It also insists on depoliticalization in the flow of official as well as private direct investment from the rich to the poor countries. It contains that aid has to be multilateral form with a view to facilitate structural adjustments in the less developed countries. It also stresses the need for restructuring the international monetary system. There has been always a great opposition from the rich countries. They have vested interests which do not allow for the healthy outcome and actions in various negotiations and their implementation. Again, the poor countries have weak bargaining power in negotiations. Further, there is a very weak trade link between the LDCs and the socialist blocs. So far, however, no result-oriented action program has been undertaken. Nevertheless, the seal of the NIEO should be continued in the interest of the global welfare. So that is with the third part of the exam guide readout for public international law. I hope it helps. If it is helpful and if you like it, please click the like button. And if you have not following my channel, please click the subscribe button to follow my channel and support me. Thank you. Have a nice day.